interfaith lawyers, the clergy, the laity, and partners including the Muslim Center for Law and Justice, the Uganda Catholic Lawyers Association, the Uganda Christian Lawyers Fraternity, and the Uganda Muslim Lawyers Association in developing this opinion, both in the expanded form and in the abridged form, which we have provided for ease of reference. The RSU notes that the bill in issue follows last year's amendment of the second schedule of the Anti-Money Laundering Act that excluded religious and faith institutions from the list of accountable persons, thereby relieving them from the burden of reporting to the Financial Regulatory Authority. The bill, however, signals a reversal of that trend, seeking to impose more, not less, more scrutiny on organizations and religious institutions. Honorable Chairperson and members, it is our considered opinion that this legislation will undeniably have a profound impact on the operations and funding for faith and religious institutions, non-government organizations, and individuals in Uganda because of the following reasons. 1, sovereignty of the people. While the bill purports to protect the sovereignty of the people of Uganda, in reading its contents, the bill usurps the sovereignty of the people and attempts to vest it in the government of Uganda, in violation of Article 1 of the 1995 Constitution that provides that all power belongs to the people who shall exercise their sovereignty in accordance with the Constitution. 2, registration requirement under Clause 14. IRCU opines that the bill, first, gives the Minister of Internal Affairs unchecked powers to revoke or suspend any registration on grounds that the activities of the agents of foreigners are disruptive in nature, pose a security threat, and are no longer fit for purpose without any due process of hearing. That clause, Clause 14, also imposes an extra burden on civic, religious, and faith-based institutions, requiring another unnecessary mode of registration, which may be burdensome and bureaucratic, since organizations are already required to register with the KCCA, URSB, FIA, NGO Bureau, Law Council, URA, NSSF, Interpol, etc., etc. Furthermore, because of the definition of an agent of a foreigner in Clause 1 is broad, this registration requirement may apply to a very wide range of lawful institutions and individuals, thereby creating stigma, surveillance risk, and operational uncertainty. Additionally, the registration requirements may lead to operational bottlenecks in the operation of NGOs and private dealings due to the lack of defined timelines in ministerial approvals. Number 3, restriction on foreign funding and foreign influence with heft penalties. The IRC observes that the penalties proposed are excessive and will tantamount to the gross violation of individual and organizational rights, since they do not align to the constitutional sentencing standards and sentencing standards, and do not conform to basic principles of proportionality of penalty. Similarly, the prescribed punishments positions the difference of different offenses specified under the bill as capital offenses. The fines and penalties set may be used to stifle the lawful activities of NGOs, individuals, religious and faith institutions in dissent of unconstitutional government policies or practices. 4. The offense of economic sabotage under Clause 13. The IRC observes that this clause may be potentially be in conflict with Article 29 of the 1995 Constitution of Uganda, which provides for public rights including freedom of association and expression. The clause risks being misinterpreted by the regulators since it's overly broad and ambiguous and may potentially be used by government to curtail ordinary business transactions, freedom of speech, and of course expression. The offense may also be used to criminalize free speech, including analyst reports, investor briefings, media commentary, research, whistleblowing, or professional opinions on economic risks. It may also discourage truthful communication about vulnerabilities in the economy and government. Number 5, governmental rights, fundamental rights, Referring to the application of the bill, Clause 2, its interpretative Clause 1, and activities as listed as restricted or described as destructive by the bill is wrong. The RCU opines that the restriction may breach the Bill of Rights under Chapter 4 of the 1995 Constitution by criminalizing the freedom to assemble and to demonstrate together with others peacefully and unarmed, and to petition government against any cause as provided for under Article 29, 1D of the 1995 Constitution. Cripple free political participation and funding of political parties guaranteed under Article 29, 1E of the same Constitution, among other violations. Number 6, powers of the minister and respective agents, including the power to revoke or deny certificates, declare a person or an organization an agent or a foreigner without an impartial due process, and the right to entry into premises for investigations. The IRCU observes that the privacy of individuals, religious institutions, and organizations as provided for under Article 27 of the 1995 Constitution of Uganda may be potentially abused by these unchecked powers. And yet, there are no proposed sufficient alternative dispute resolution mechanisms proposed in the bill. Furthermore, this legislation conflicts with existing laws like the Data Protection Act, the Anti-Money Laundering Act, the Public Finance Management Act, by mandating public disclosure of sensitive data and duplicating offenses with harsher penalties and fewer safeguards. Number 7, designation of citizens as foreigners. A foreigner is defined as a citizen of Uganda and residing in another country. The RSU observes as follows: the designation of a non-resident citizen of Uganda as a foreigner is derogatory in nature and conflicts with the constitutional guarantees for citizenship under Chapter 3 of the 1995 Constitution. A Ugandan citizen cannot be categorized as a foreigner. One cannot simultaneously be a citizen and then rendered a foreigner at will by law. The categorization of Ugandan citizens residing abroad as foreigners will stifle the channeling remittances from labor externalization and limit foreign funding to the detriment of the country's database, taxable database. Additionally, being deemed or designated as an agent of foreigners by the Minister of Internal Affairs without any due process is derogatory in nature and a gross violation of rights of citizenship. Chair, what this means is that once somebody leaves this country, they lose their citizenship by virtue of geography. Number 8, policy engagements. Part 2 of the bill intends to prohibit a wide range of activities under the guise of protecting sovereignty. The Intelligence Council of Uganda observes as follows. 1. These restrictions may stifle advocacy, civic and voter education, restrain election monitoring, policy engagements, especially those that call for accountability from government and economic reporting. This may also shatter the prophetic role of religious leaders, as they will not be expected to comment on political, electoral, or governance issues of any kind. The bill may potentially limit investments by the religious, faith, and non-government organizations in key priority areas, including, but not limited to, education, health, agriculture, among others, by requiring a special permission to engage in them. Yet, private institutions, like religious institutions, are partners of government in the socio-economic transformation of the country. Restrictions on funding under Clause 22. The Inter-Religious Council of Uganda opines that this is one of the most consequential provisions. It may affect churches, NGOs, schools, humanitarian bodies, private businesses, development programs, and diaspora-supported initiatives. I must hasten to add that even mosques will be very badly affected. It may also slow investment, remittances, and legitimate international support. This clause may further give government an opportunity to control, to monitor, and or take income of the religious institutions, which amounts to government interfering into the affairs of religious institutions and other entities. Furthermore, the clause may violate the right to operational independence of individuals, private entities, religious institutions, and NGOs due to the possibilities of operational bottlenecks. Number 10, declaration of source of funding and reporting under Clause 21. The IRSU opines that these clauses may give government a far-reaching right to interfere with the internal and private matters of individuals and organizations, including their funding. The clause creates recurring compliance obligations backed by criminal sanctions, increasing administrative burdens for organizations and exposing them to enforcement risk for technical non-compliance. The provisions risk to violate the privacy of institutions and disrupt normal business operations and transactions. In addition, the information required here is already required by other government agencies, as we all heard, especially from the last speaker. This overlaps with existing anti-money laundering, know your client standards in financial management, and source of funds obligations. It also raises confidentiality concerns, especially where declarations may be accessible on payment of a fee. Our recommendations to Parliament, the interreligious recommendations to Parliament. It is our considered opinion that Parliament should deliberate on the following recommendations before passing the bill. The Parliament should revise vague and overly broad legislative piece to ensure that they are narrow and precise, that you have specific definitions like the meaning of a foreign agent or a foreigner, or interests of a foreigner, public interest, economic sabotage. All these need to be carefully reconsidered. The Parliament should limit excessive and unrealistic ministerial powers of the minister under the bill, specifically the discretion to register or deregister organizations and approve funding without independent oversight. There should be a clear, established fair hearing and appeal safeguards within the bill to protect, to check the powers of the minister and the respective department for peace and security. Parliament should strike down provisions that are criminalizing lawful fundraising activities by Ugandans living abroad, and those that may affect remittances in support of local investments and families, as it is likely to affect the socio-economic progress of the country and partnerships in development. Parliament should put in place mechanisms to enable ministerial coordination in implementing the bill, strengthen and establish a central registry for information already shared among government agencies, since the information that is required in the registration processes is readily available to the NGO Bureau, URSB, banks, Financial Intelligence Authority, Interpol, and the Uganda Police, among others. In the alternative, the IRCU and its partners recommend strengthening the capacity of the Financial Intelligence Authority, FIA, in respect to implementing the bill, rather than creating another registration framework under the Department of Peace and Security. The IRCU and its partners recommend that government should strengthen private-public partnerships instead of stifling the engagement and participation of NGOs, religious and faith-based organizations, in policy formulation, implementation, and development, inclusive of governance requirements for the participation of all stakeholders, regardless of background or status, to have a voice in shaping policies and institutional practices, promoting equity, participation, and social justice. The IRCU and its partners recommend the creation of an alternative dispute resolution mechanism to expeditiously address matters arising from the actions and omissions of the minister or the Department of Peace and Security before any court process For example, creation of a functional interministerial tribunal, since the functions under the bill overlap with the mandates of other agencies. This will address the issue of backlogs in the courts and guard against the unnecessary delay of justice in business and related transactions. 7. The punishments generally proposed in the bill should be reasonable and proportionate, aligned to constitutional guarantees and sentencing guidelines. The law should not restrict the amount of funds to be received, but instead strengthen the existing entities like the FIA, the Bank of Uganda, the NGO Bureau, and the Deposit Protection Fund of Uganda that requires proof for the source of funding and the purpose of the funds received. Parliament should consciously safeguard the protection of the constitutional freedoms and rights as provided for in the Bill of Rights under Chapter 4 of the 1995 Constitution as amended, especially freedom of association and expression, the right to fair hearing before administrative bodies, the right to acquire resources, to run faith, civic, and political organizations from other sources as apart from government, among other rights that may be stifled under the bill. There is no need to respect the independence of faith. There is need to respect the independence of faith and civic institutions, which is a fundamental principle that is respected in various international and national frameworks, potentially leading to the social, economic, and political development of the country. The bill needs to recognize the role of civic, religious, faith-based organizations in service delivery in Uganda, which may potentially be undermined by the bill. The RSU recommends that since this bill will have a significant impact on the socio-economic development of the country, the bill should be considered as one of the subjects for discussions in the envisioned national dialogue. Conclusion. And Chair and members of the committee, this is a harmonized position. Given the above reasons, the Inter-Religious Council of Uganda rejects the bill in its current form due to the possible constitutional violations, including the possibility of the bill.
Honorable colleagues, you know how we do it. Thank you. Thank you. Please go on. You are protected.
Thank you. I need to read that sentence again.
Please read it.
I'm going to read it again because was that an interruption or
No. Please go on.
Okay. Chairperson and honorable members, given the above reasons, the Inter-Religious Council of Uganda rejects the bill in its current form due to the possible constitutional violations, including the possibility of the bill shrinking civic space, endangering both civil, religious, and political rights, while creating legal conflict with the existing financial regulations as highlighted herein. Honorable members, a strong law is not one that restricts broadly. It is one that distinguishes carefully. If we draw the line, we'll protect the nation without weakening the very people who sustain it. It is our considered opinion that the government needs to align foreign funding oversight with the existing anti-money laundering and financial intelligence authority frameworks than creating a parallel regime that will eventually curtail the sovereignty of the people of Uganda. we respectfully caution Parliament that if the bill is passed as it is, it threatens the existence of religious and faith-based institutions and organizations, as it will stifle their funding base, open up their financial and internal affairs to the scrutiny and oversight of government, while grossly hindering religious freedom, independence, and evangelism. Finally, considering where the country is, since we've just gone through a polarizing exercise, elections, we as religious leaders feel that the efforts of key institutions like Parliament should be focused on building bridges, nurturing harmony. We are therefore troubled that we are focusing on a bill like this, which will further destabilize and unsettle communities. It is therefore our considered view, and also the expectations of the population, that there are more pressing issues affecting them that should be preoccupying your and our time and resources to address. I say all this for God and my country. And I thank you, Chair.
Thank you, thank you. Thank you, Interreligious Council. Where we all agree with you is that the bill in its current